On item 1.
Your Lordship.
I think there are some mentions. Yes, sir.
Your Lordship,
My lord.
sorry, Mero, item 3. Your Lordship.
Item 3, although it is fixed for today, my lord, for hearing.
In the
I
hearing
have-
list.
Yes.
Yes, my lord.
Yes.
I have personal problem. My first cousin died last night.
Sorry, I'm so sorry.
So
Yes.
the marriage may be fixed in the first week of December, my lord.
Okay. At the request of Mr. So-and-so, senior counsel appearing for the appellants, appearing for the respondents, which is not objected to by Mr. So-and-so, and counsel appearing for the appellants. List this matter again in the first week of December
my lord.
for hearing. Yes.
Obliged.
Your Lordship, if this item 4 may come up on the 24th, next week,
Item 4 of
a hearing list. Yeah.
hearing list
Yes.
may come up after
24th, next
on the
week,
24th.
Monday, coming Monday. I'm obliged.
Okay. At the request of so-and-so and counsel appearing for the party, place this matter again on the 24th of November
I'm obliged.
for further hearing. Yes.
Yes, Your Lordship, hearing cost is item number 18.
18
Yes. Let
Yes.
the matter may be taken up this coming Thursday.
on Thursday.
Yes,
Okay, Thursday.
yes,
We don't need to pass any orders, just call it on Thursday, not today.
yes, oblige Your Lordship.
Yes.
I seek Your Lordship indulgence. My Lord, part 2, item number 12 and 15.
12
12 and 15.
and 15, yes.
My Lord, with regards to item number 12, the learned amicus curiae is out of station. So if this matter may kindly be taken up after 2 weeks.
Okay.
Item number 12.
But that's a criminal appeal jail.
My lord.
Some more diligence will be expected on the next.
My Lord, my Lord.
And what about
And
15?
in item number 15, my senior, Mr. Ralph Okoma, is the empaneled advocate. So we, his juniors, cannot take this matter in his absence. So if this matter may kindly be taken up after 1 week.
Okay, in item number 12, you write, the learned, at the request of the learned counsel for the amicus curiae, who has expressed some difficulty today, let this matter be listed after 2 weeks.
My Lord.
2 weeks. And in item number 15, you are appearing for the respondents.
No, my Lord, I'm appearing for the appellant. My name is at serial number 2 in the second line.
Okay. In 15, you write, at the request of the learned counsel for the appellants, which is not objected to by the learned counsel for the respondents, let this matter be listed on
After 1 week, my Lord.
after a week.
Deeply obliged.
Okay.
My lord,
Yes.
item 19 of hearing list,
Item 19, hearing list, yes?
if it can be taken up tomorrow, my lord. I have
Tomorrow.
taken the consent of the parties.
Okay, tomorrow.
My Lord.
Obliged, my lord.
Don't call this today, tomorrow. Okay.
Item 1.
Yes, item 1.
May I please, my lord?
Yes.
My lord, in this matter, my lord, in terms of order dated 22/9/25, my lord, we were supposed to file additional affidavit, my lord, explaining the reasons as directed by my lord. My lord, I am praying for a little accommodation, my lord. I am extremely sorry, my lord, that we could not file affidavit. My lord, will fix this matter on Friday. In the meantime, the affidavit is ready, my lord. Due to some change of officials, my lord, it could not be executed. My lord, we'll file affidavit within this week, my lord, explaining, my lord, as per the order dated 22/9, my lord, we explain the reasons, my lord, why we could not comply, in what circumstances the order was not complied. And secondly, my lord, the issue regarding this payment of interest, my lord, is the Honorable Division Bench is in session of the matter, my lord, and these matters, my lord, have been transferred to principal seat. And my lord, the next date in that matter is fixed on, my lord, December, 4th of December, my lord.
I think yesterday we were going through some judgment
My lord.
by the apex court which says that mere filing of an affidavit, mere filing of an appeal is
That
not
is
going
true,
to
my
give you
lord.
any benefit out of it. And in fact, I think penalties were imposed for taking that ground.
My lord, but the issue, in my humble submission, my lord, in that matter also the contempt is listed along with the writ appeal.
Because that matter is not an appeal on these.
My lord, but
Orders.
the issue is same, my lord. If I
Doesn't
may
work,
humbly
you
submit,
doesn't work.
my lord has already recorded it also in the last
Doesn't
occasion.
work. We'll give you time till Friday.
My lord, my lord.
We'll give him time till Friday, but when do we have it listed then? Next week?
Next week, my lord.
Okay,
Next, my lord.
take down. Mr. So-and-so appears for the petitioners, full stop. Mr. H. Gupta, Learned Counsel appearing for the respondent number 7, has submitted that he would, that the respondents request an accommodation till Friday
My lord.
to file their affidavits and bring the same on record in accordance with the earlier orders passed by this court, full stop. Reluctantly, time till, what is that date? 21st of November is allowed to the respondents, full stop. List this matter again on 26th of November, along with the affidavits proposed to be filed by the respondents, full stop.
My lord, let it be final chance, my lord.
Huh?
Let this be final chance because we are giving.
It is made clear that the absence of any affidavit on record on the next date of listing would be viewed seriously by this court.
Much obliged.
Yes.
Item 2.
My lord, a D card in respect of the respondent number 4 and 5 has not been returned yet. So, my lord, if service may be awaited,
Mr. So-and-so, Learned Counsel appears for the appellants, full stop. It appears that the AD cards in respect of respondent number 4 and 5 are awaited, full stop. Who appears for the others?
none, my lord. Even though steps, service has been completed, my lord. None appears.
And this affidavit, respondent number 3. Who are the other respondents? An affidavit has already been filed by the appellants with regard to service of notice by way of paper publication on the respondent number 3. What about 1 and 2? Respondents number 1 and respondent number 1 was served by way of Dusty. What about respondent number 2?
My lord, fresh steps were taken already with the respondent number 2.
On respondent number 2, something has to be
Yes,
done
my
about
lord.
him also.
My lord.
Oh, respondent number 2 is in custody.
My lord.
Respondent number 2 has been stated to be in custody. Why can't you serve him in custody through the jailer, if you know that?
That can be done.
He needs to know about the case.
My lord, my lord.
He may
That can
make
be
his
done.
arrangements.
Yes.
So now then, perhaps you have to bring that on record, the documents showing that, because that is the order. If you
My
go
lord.
through this order, 12/6/2025, already you had made a submission that he is in custody. You are required to give the details.
My lord.
So give the details, we'll have it served upon him.
My lord.
The Learned Counsel for the appellant prays for an opportunity to bring on record the fact that the respondent number 2 is in custody in a jail at Itanagar. Full stop. Awaiting service report on the respondent number 4 and 5. Place this matter again after 2 weeks
My lord.
on a date to be fixed by registry.
I'm deeply obliged.
Should it come up in the orders column? Why is it coming up in the admission column?
My lord.
In the
because-
orders column,
Yes.
service report.
My lord.
Yes.
Item 3.
Lordship, as per the last order,
Huh?
the respondents have filed their additional affidavit,
Huh?
and I've also filed my reply affidavit. Your Lordship. So the
My lord, I will be granted 2 weeks' time to take instruction
On the reply?
on the reply, my lord.
Okay. Will they do? So what was the subject matter, sir? What is the subject matter of the petition? Okay. It has been submitted by the learned counsel appearing for the petitioner that the affidavit in reply has been filed, and the learned senior counsel appearing for the respondent has also acknowledged receipt thereof and prays for some time to have his instructions on the reply file, full stop. Accordingly, list this matter again after 2 weeks
2 weeks, my lord.
on a date to be fixed by registry.
Oblige.
Item 4.
In this case, my lord, I have just received the paper book.
My lord,
Yes.
we will be appearing on behalf of the respondent. We have already filed our Vakalanama, so we need some more time to go through the case. So if the case may be listed after a week.
Yes, sir.
No problem.
Okay. Mr. Suensul and the council has submitted that they have filed an wakalatnama to appear for the respondents,
Sole respondent.
or for the sole respondent. Full stop. He prays for a accommodation for a week. Full stop. Learned senior counsel appearing for the appellants does not object to the same, and therefore let this matter be listed after a week on a date to be fixed by the registry.
Highly
Yes.
obliged.
Oblige.
Item 6.
Yes, the IA. You have filed your objections?
My lord,
Interlocutory.
it was the end of October. I applied for certified copy. Till today, I have not received certified copy. That
Of
is why.
what?
Certified copies of impugned order.
My lord, we have already annexed.
Interlocutory order.
A long time has gone.
Interlocutory application. Why don't you give him a copy?
We have already given.
You're waiting for the certified copy of the
Yes,
order.
yes, yes. For
The
the
copy of the order would be along with the interlocutory application, no?
yes, yes. My lord,
I see
even
with
without that, we
132.
can proceed.
Huh?
We can proceed.
Oh, we can proceed?
Yeah.
With the IA or with the appeal?
I have been waiting for a long time, wasting time.
So, my lord,
Where is this is the original file. The original is not there. Huh? Oh, yes, it is here. I'm so sorry. It is here, it is here. It is here. What is the order?
my lord, in DIA,
No, what is the trial court order?
yes.
Executed on after respondent to make payment, in fact, respondent contracted all respond to suit and So you were the respondent in the
Yeah, at the trial court.
defendant, है ना?
Yeah, defendant.
And he has got a stay in his favor.
Yes.
You want a stay of that stay?
Yes, yes.
Why?
But, my lord, the thing is that we have occupied all the building. We have rented out some floors as for garage. So by taking a chance of disorder, they are trying to put the building under lock and key. And we are restrained from taking the garage rent also.
If
So,
you go
but,
by the simple, if you go by the simple plaint,
Yes.
the allegations in the plaint, your position does not seem to be appropriate. You told them that you'd buy the land, then you did not buy the land, yet you took possession of the entire property.
So, my lord, in the main suit, what they have seek for is possession of the land still. So, it is at, if I may take your lordship to page 21.
It was your land.
Yes, my land. So, actually, I have
What is the
mortgaged.
facts? The facts is that
The
you...
fact is that we have lent some money from him, then we have put our LSC as a security. So we could not pay in time, and that's why they are trying to take possession by filing the suit. If I may take your lordship to page 21 of the memo of appeal, page 21.
Yes.
Yes, my lord. If I may take your lordship, page 21 of the memo of appeal, that is the prayer portion at the last sentence. If I may read. So, in the facts and circumstances stated above, the plaintiff humbly prays that this honorable court may graciously pass order and decree declaring that the plaintiff has the right to possess and mutate into his name LSC number so and so located at Damveng, Aizawl, Mizoram, and to direct the defendant to vacate the suit property immediately. So they are trying to seek possession by way of filing this suit. So they have not any injunction, permanent injunction in the main plain also, they are pleading. So without permanent injunction, how can we grant temporary injunction? So temporary injunction is in aid of the main prayer. So there is nothing to aid about their pleading. So still they are trying to seek possession by way of filing the suit.
And how does the trial court deal with it?
The trial court, in my opinion, the trial court order is also, it's a kind of, it could be vast interpretation. It is, if I may take your lordship to, just after the index of the memo of appeal.
There is a very recent Supreme Court judgment saying that if a party is in possession, then temporary injunction regarding these issues may not be permissible. So rent is being paid to whom now, after the orders?
After the order, the trial court verbally directed us not to collect the rent.
Are you collecting the rent now?
Yes.
Huh?
Both of us are collecting, I suppose. We are
Both?
collecting.
No. We did not collect. After, at the trial court, yes, after passing the order, we collect. Then they filed an application under Order 32A for disobedience of the order. But the interpretation we have regarding the order is different from what they mean. So the trial court only directed against us. The respondent is hereby restrained interfering in the suit land located at Thakting Dambeng until further order of this court. So we are restrained to interfere only. So we are not trying to sell or to dispose of. So there is no particular such order.
But show us what is wrong in this order. You are saying this order should be modified. Why? What is wrong in this order?
So by taking a chance of this order, they are trying to put the building under lock and key. So they have contacted all the tenants to...
Pray for a modification that you would not interfere, but there should be a status quo. Building should not stop running. Let all the rent be deposited in the court. Whoever wins in the end of the day gets all the money.
But my lord, technically also...
We support that.
He supports it.
But my lord, technically we are in a position of the sued land. So we
Where
are...
is the judgment? I just said there is a judgment from the Supreme Court saying
Yes, I know.
what would happen in a case where the defendant is in possession, but prays for a temporary, plaintiff prays for a temporary
Yes,
injunction that I should be allowed to handle the property. What happens then? Very recent judgment, around 2-3 days ago.
So
What, we admit the appeal? Admit the appeal, take it up for hearing on the next week.
Yes.
Be prepared.
Yes, Mike.
There's no use only
okay.
doing it for the stay. Anyway, not before next month. You don't collect any rent before the next month. Only when the month starts, you'll collect. Learned Counsel appearing for the... No, I heard the Learned Counsel appearing for the parties, contesting parties. Full stop. It has been submitted that... You want to file any pleadings on this? On the main FAO? Huh?
No need, my lord.
Not needed. It has been submitted by the Learned Counsel for the parties that the matter may be taken up for disposal at an early date in the next week. May be taken up for disposal in the next week. There is no stay of the suit. Suit is
No.
proceeding.
No, proceeding.
Full stop. Accordingly, let's this matter again in the next week at the request of the parties. Have it argued out next week. Have your judgments ready. You also
Yes.
get your judgments ready, whether this temporary injunction can be given or not.
Okay.
When you have heard his argument, there is no permanent prayer for permanent injunction, can he grant it?
Okay.
And you find out whether
Yes,
These
I
orders
already have, but
you should be prepared. Yes.
Item 7.
Lordship, I'm appearing on behalf of my senior Central Government Counsel for Respondent number 1. Lordship, may I seek another 3 weeks' time for filing affidavit in opposition?
Respondent number 1.
Yes, my Lord.
Lordship, I'm appearing on behalf of my senior, who is for the respondent 2 and 3, and we have filed our affidavits.
You have filed it.
Yes.
And 1, 2 and 3, what about the rest of them? 6, 7, 8, 9?
Yes, Your Lordship, I'm appearing on behalf of the state respondents, number 4 to 8. We have also filed our affidavit, Your Lordship.
Heard Ms. Swensol and the council appearing for the petitioner. It is submitted that the respondents number 2, 3, 4, 5, 6, 7, 8, represented by their respective councils, that the affidavit on oppositions have been filed on their behalf, full stop. The learned council appearing for the respondent number 1 has prayed for an accommodation of
3 weeks.
3 weeks. What is the subject matter? Just a minute. There's soil on the petitioner's land.
Yes,
Why
yes,
do
my
you
lord.
require 3 weeks for that?
Lordship, we did not receive instruction yet.
Sorry?
We did not receive instruction yet.
Who is the respondent number 1 who's not giving instruction?
Ministry of Home, Ministry of MORTH, my lord.
And who appears for 9?
It seems, my lord, the respondent number 9 is not appearing today.
No.
None.
Mr. Lalrichenga Shankti has entered appearance on behalf of respondent number 9. Where is he? Okay. What did I say? Respondent number 1 prays for time to accommodation for?
3 weeks.
For 3 weeks. To file their affidavit in opposition, full stop. None has put in appearance for the respondent number
9, my lord.
9, full stop. The prayer in this petition is for a direction to the respondent authorities to remove the illegally dumped soil on the petitioners, to remove all the illegally dumped soil on the petitioner's land, which according to the petitioner has been dumped by the respondent number 9
Yes, my lord.
while carrying out a project work under the respondent number 1.
Yes, my lord.
Notice in this writ petition had been issued on
On 18.
962025. Full stop. The allegation of the petitioner is that due to the dumping of the soil on her land, on his or her land, on his land, comma, he has not been able to properly use his property, full stop. It is not understood as to why. Why the respondents require further time to file affidavit in opposition when the only issue is whether the land, whether the soil has been actually dumped by either of the respondent number 9 by the respondent number 9 on the while carrying out the project of respondent number 1, although such property of the petitioner was not required to be disturbed while carrying out the project, full stop. This matter again in the first week of December. Yes, choose a date on the first week of December. Respondent number 1, please choose a date.
4th of December.
4th of December 2025 at the request of the Learned Council for the respondent number 1, by which time the respondent number 1 and respondent number 9 shall ensure filing of their responses, if any, to the writ petition, full stop. It is clarified that no further time would be allowed to the two respondents to respondents on the ground that instructions are yet awaited, full stop. The respondent number 9 also is directed to ensure presence on their behalf on the next date fixed, full stop.
You oblige.
Item 8.
May it please your Lordship, I am appearing on behalf of the state respondents 1 to 5. Your Lordship, in this case, I am yet to receive instructions, so if I may be granted at least 2 weeks' time, your Lordship, to
This
file
is
my
item
affidavit.
9.
Yes, 8.
Item?
8, your
8,
Lordship.
I heard 9, sorry. You are appearing for?
Your Lordship, respondent number 1 to 5, state
1 to
respondents.
5.
The
What
matter
is
was
the-
last listed on the 9th of September, your Lordship.
What is the prayer? Family pension. Who appears for the petitioner? None. Ms. So-and-so Learned Counsel appearing for the respondent number 1 to 5 has prayed for an accommodation for
2 weeks, your Lordship.
2 weeks in order to allow, in order to enable the respondents to file their
If it,
response to the writ petition, full stop. The matter relates to a claim of family pension. Full stop. It is expected that the respondents would have their affidavit on record by the next date fixed. Yes. List
Much
again
obliged,
after
Your
2 weeks on a date to be fixed by the registry.
Much obliged, your Lordship.
Item 9.
Yes, madam.
My lord, this is bail application. However, my lord, the learned PP is on legs, so they were praying if the matter be listed, pass over for a while and maybe listed as the last item.
Okay. Call it after last.
Obliged.
Item 10.
Your Lordship,
May it pleases your,
Yes.
may it pleases your lordship. My lord, may kindly come to page number 15, and that's my case all about.
Your Lordship,
Page 15.
Your Lordship,
Page 15 is mine.
the PP is
Mr.
not.
Biswas, just a minute.
The
Yes.
PP is on legs in the other courtroom, your Lordship. So similar.
Can we
prayer-
have it after some time, Mr. Biswas? The PP is on legs in the other court. After some time?
Absolutely, no, absolutely.
Item 11.
Sorry. May it please your Lordship, the paper book has to be prepared in this RFA, your Lordship. It's yet to be prepared.
Learned Counsel appearing for the appellant has referred to the office note dated 13/11/2025, which reflects that the trial court records have been received. Full stop. So and so appears for the
Respondent number
respondents.
1 to 6.
Full stop. List this matter after 3 weeks after preparation of the paper book on a date to be fixed by the registry.
Much obliged, your Lordship.
Item 12.
The PP is not there.
Yes, your Lordship.
PP is not there, sir. Could we have
No,
it
sir.
after some time? The PP is not there. She's
Oh,
on her
yes.
legs in the other
Yes,
court.
yes.
After some time?
Correct.
And 13 will also be the same? Okay.
Yes, your Lordship.
Your Lordship, I'm appearing for the petitioner. This is a bail application, Your Lordship.
Ma'am, the PP is perhaps in some other court. We are taking up
Your
the bail
Lordship.
matters after some time.
Your
End of the
Lordship.
list. Okay.
Item 14.
Service report on 213 awaited.
Yes, my lord.
Office note dated 13/11/2025 reflects that the service report in respect of respondent number 2 and 3 is still awaited, full stop. Mr. So-and-so appears for the appellants. Ms. So-and-so appears for, you are appearing for what?
Respondent number 1, my lord.
For respondent
And
number
I have
1.
already filed my counter affidavit.
Ms. So-and-so appearing for the respondent number 1 has submitted that the counter affidavit on behalf of the respondent number 1 is already filed and is on record, full stop. List after 2 weeks on a date to be fixed by the registry along with the service report on respondent number 2 and 3. Yes, please.
Oblige.
Item 15.
Yes, sir.
Lordship, service upon respondent number 3 is still awaited.
Who is 3?
And the owner of the accident vehicle.
The, who is he, the driver? Or
No, the owner. The
owner of the vehicle?
Yes, my lord.
Service office note dated, not service report. Mr. So-and-so is appearing for the applicants, full stop. Service report dated at 3. It's not service report, it's office note dated 13/11/2025 reflects that the service report in respect of respondent number 3 is awaited, full stop. List this matter after 2 weeks on a date to be fixed by the registry.
Oblige, my lord.
Awaiting service report on the respondent number 3.
Item 16.
Yes.
Lordship, as per the office noting dated 13th of October, service is complete on respondent number 1, but no one has appeared till date.
Respondent number 1 is?
He was the plaintiff in the trial court, in the lower court. Thirteenth of October.
Yes. Service office note dated 13/10/2025. Yes. Take down. Had Mr. So-and-so learned counsel appearing for the appellants, applicants. Service office note dated 13/10/2025 reflects that the AD card showing service of notice on respondent number 1 has returned back and is kept in the part of the record, full stop. However, none appears for the respondent number 1 today, full stop. List this matter again after 2 weeks on a date to be fixed by the registry, enabling the respondent number 1 to put in appearance on his behalf. Full stop. Yes.
Item 17.
Yes. What was this IA for?
My lord, this IA 213 is for substitution of the appellant number 4, but after going through the brief, my lord, I am seeking withdrawal of this IA as not pressed because the appellant number 4 was expired on January 2025, and this appeal was filed sometime during May 2025. And at the time of filing this appeal, my lord, we had filed on representative capacity already. So this is not required. This IA is not required.
It is not required.
Yes, my lord.
Mr. So-and-so learned counsel appearing for the applicant. This is an IA civil, okay?
213.
213 of 2025, huh? Mr. So-and-so learned counsel appearing for the applicant has submitted that he has instructions not to press this IA. And it is submitted that the appeal may proceed without substitution as prayed for in this IA, full stop. Prayer is not objected to by the learned counsel appearing for the other parties, full stop.
Lordship, will be appealed.
We are, he's withdrawing the IA, we'll have the matter fixed, the other matter fixed after preparation of the paper books. Okay. Other respondents do not object to, learned counsels appearing for the other parties do not object to the submission made, full stop. Accordingly, this IA, civil number 213 of 2025 is disposed of as not pressed. Office, in the RFA you write, office note dated office note dated
Lordship will be appearing on behalf of respondent number 4.
In the main case, in the main
case. Who's the respondent number 4?
The private respondents.
Okay, you take down in the main case. The Mr. So-and-so has put in appearance today on behalf of the respondent number 4. What about the other respondents? The other respondents are, the state respondents are already represented by Ms. So-and-so. Full stop. The office note dated 13/11/2025 reflects that the paper book is under preparation. Full stop. Accordingly, list this matter after 2 weeks on a date to be fixed by the registry, along with the paper books being supplied, along with report of paper books being supplied to the learned counsel appearing for the parties.
And the interim may be continued. Otherwise, my lord, this IA can also be disposed of.
Which
IA number 90. We're seeking for restraining the respondent's pendency of the appeal.
You are praying for what?
To restrain the respondents.
There is already an interim
from
order.
authorization. Yes, my lord.
Yes. What do you say? He's saying dispose it of.
Having the appeal admitted, my lord,
Huh?
the appeal is already admitted. During pendency of the appeal, my lord, it will be just and proper to allow this IA to direct the respondents not to make any alteration within the suit property.
It has been submitted by the, you take down, yes,
There's no objection.
we will close this. It has been submitted, this is in IA 90 of 2025. Stop. It has been submitted by the learned counsel appearing on behalf of the applicants that since the appeal stands admitted and an interim order is already in operation, this IA may be disposed of. Directing the parties to maintain status quo as of today during the pendency of the appeal. Full stop. Learned counsel for the appearing for the parties have not objected to the said prayer since the interim order is already operating during the pendency of the appeal. Full stop. Accordingly, this IA stands closed by directing the parties to maintain status quo as of today on the suitland during pendency of the appeal. IA accordingly disposed of.
Item 9.
Deeply obliged.
Lordship, seeking for Lordship's indulgence. My item is at item number 12. The other items which are to be taken up are fixed matters, bail matters. I'm also seeking for bail. Lordship, it's only for the purpose of issuing a notice to the respondent.
Item number
Public prosecutor. 12, yes.
Okay. 12, yes. We are taking up 12 first, madam. Heard Mr. So-and-so, and counsel appearing for the, senior counsel appearing for the petitioner, full stop. This is an application filed under section 483 BNSS, read with section 37 of the NDPS Act, seeking bail for the accused applicant in connection with Zokhauthar PS case number 36 of 2025. Pending before the special court under the NDPS Act at Champai. Full stop. Issue notice. Extra copies you have given?
Yes.
Issue notice. Ms. So-and-so and a PP appears for the respondents. Full stop. Call for the updated CD list. On when can you have the CD, madam?
Your Lordship, since the matter is at Sampai, at least 1 or 2 weeks' time.
The matter can be taken up before vacation, Your Lordship.
It is today is the 17th, we'll fix it on the 1st of December?
1st of December.
1st of December?
Right.
1st of December would do, ma'am?
Yes.
List the matter again on 1st of December,
Oh, please.
allowing the learned PP to have her updated CD. Yes.
Item 10.
No, this was item? No, this was 12. Where is 9? Get me 9. Oh, 9 is not here again. 10. Okay. Again, he is not here.
May it please your lordship?
Yes, you are at item number?
10, lordship.
10, yes.
Lordship, this matter may be taken up after some time, lordship. My senior, he is on legs.
We have only,
at principal bench.
3 matters left. We have only 3 matters left.
Okay, lordship,
ask
after
him to
3
be here
matters.
soon.
Your Lordship, may I please make a mention with regards to item number 12? It seems that charge sheet is already submitted in the matter. So would it be more proper if this registry is directed to call for a scanned copy of the charge sheet from the learned trial court?
Yes, in item number 12, you kindly inform him that we are adding that
Yes,
matter.
yes.
Because updated CD, if the charge sheet is submitted, nothing doing.
Charge sheet was
in
already filed on September 2025.
Charge sheet was filed.
Yes.
In item number 12, you take down. It has been pointed out by the learned PP that the matter has already been charge sheeted on 15th?
On 3/9/2025.
On 3/9/2025.
Yes.
Full stop. Registry to call for the scanned copy of the trial court records. Full stop. List as directed before.
Deeply obliged.
Yes. Oh, this is the one we are taking up. This is item 10. He wants it after some time. 9 is not there.
Item 13.
13.
May I please, your lordship?
Yes.
This is a bail application, your lordship, and the sections are under section 21C, 25, 29 of NDPS Act, your lordship. And it is of a commercial quantity. Before I start the hearing of the bail application, your lordship, I would like to inform the court that the accused person, the petitioner hearing, is an HIV patient, and he's been in judicial custody since 7/9/24, your lordship. And as per the prosecution case, your lordship, a drug was seized, and there are 2 accused actually basically in this case, your lordship. One was juvenile, who already pleaded guilty in this case, and he's already been he has pleaded guilty and he's completed his sentences, your lordship. In my case, your lordship, there's no possession has been the contraband possession has taken from my possession, your lordship. I was not there, and this has been, your lordship, if we look at the evidence of witness number 2, who was the Caesar witness, your lordship. That is on page.
Madam, we'll have to
Issue notice. Yes.
issue notice, call for the scanned copy of the trial court records for the moment. And we
Your
can
lordship,
have
and also for the JGB records, your lordship, because it's a connected case and he's already pleaded guilty in this offence.
Now we'll call for the records of the scanned records of the trial courts. All the documents available there will come on record.
The JGB one will also be there, your lordship.
That would be required.
Yes, your lordship, it's very much required for our case.
Okay. Heard Ms. Swinsol on a counsel appearing for the petitioner. This petition has been filed seeking under section 438 of the BNSS, read with section 37 of the NDPS Act 1985 for grant of regular bail to the petitioner in connection with Bangkon PS case number 388 of 2023, which is pending in the court of the in the special court, NDPS 1985 at where there's only one here. The charge sheet has been submitted in this case on
4th December 24, Your Lordship.
4 December 22. Full stop. Issue notice. Ms. Swenson appears for the state respondent. Call for the scanned copy of the registry to call for the scanned copy of the trial court records. Stop. The learned counsel for the petition has submitted that the records of
Juvenile JJB case record, case number 59 of 2023, Your Lordship.
Did you get it?
State Mizoram versus Abdul Qadir Laskar, that is in para 14, Your Lordship, page 8.
Just on page.
Page 8, Your Lordship, para 14.
The learned counsel for the petitioner submits that the case records of JJB record case number 59 of 2023, comma, State of Mizoram versus Abdul Qadir Lashkar, comma, juvenile, would also be required for perusal. Full stop. Learned PP does not object to the same. Accordingly, the registry would also call for the records, a scanned copy of the records of the JJB record case number 59 of 2023 from the concerned court. Full stop.
Your Lordship, I have one more prayer, Your Lordship. The petitioner is a HIV positive person.
We'll
Though
take
it
care
has
of
not been reflected in the charge sheet, while after that is
we'll
the
take care
medical
of
has
that.
not been reflected. But Your Lordship, there's another thing is there. As per the HIV and AIDS Act, Your Lordship, as per section 31, he should be getting the regular medical treatment for his. But he's not getting it, Your Lordship.
We'll observe that. We'll observe that. List this matter again on. By when can we have it?
And
Scan copy. How much time it takes? First week of December. On the 4th of December 2025. Along with the records which have been called for. Full stop. The learned counsel for the petitioner has submitted that though the petitioner is a HIV positive patient, comma, he has been awaiting, no, he is, don't say though, the learned counsel for the, cut out that sentence, the learned counsel for the petitioner has submitted that the petitioner is an HIV positive patient and therefore he would require continuous medical supervision and antiretroviral therapy, full stop.
Yes.
The learned PP is requested to apprise the jail authorities regarding the medical condition of the petitioner who shall, if required, verify and thereafter make available proper medical attention and antiretroviral therapy to the petitioner as required.
Yes. Oblige, Your Lordship.
Yes.
Item 10.
Yes, sir.
This Lordship. My Lord, page 15 is my case. 1-5.
Mr. Biswas.
Allegedly,
Mr. Biswas.
218 grams of...
Mr. Biswas.
My Lord.
There is a saying that even if everything goes in your favor, something messes up. The bail application is not paginated at the top.
My Lord, it has been done by the... I am given to understand, my Lord, the pagination in Aizawl bench. Perhaps I may be wrong, my Lord. I am not that much sure. It's done at the bottom, my Lord. Page 15, 1-5.
Okay. Okay, ground of arrest, yes.
This is my case, my Lord. I mean, the rigors of 37 will not apply. Even if it would have been applied, this is squarely, my Lord, an illegal arrest, out and out, my Lord, in view of my Lord. This is a mere intimation of arrest. No ground, nothing. This is a mere intimation of arrest. This does not anyway indicate any grounds for arrest.
Yes, madam. Page 15.
Yes, Your Lordship.
That's my case.
First, what I would like to mention is that, Your Lordship, this application, the bail application was never applied before the trial court. So they have jumped up to the High Court for the first time.
When the person is not intimated about the ground of arrest.
My Lord, it is in my humble opinion that first of all they have to approach the trial court instead of jumping up here.
My Lord, this matter was in fact in the principal bench while Justice Sridhar Rao was the acting Chief Justice of our High Court. He used to insist on this, and an order was passed against which the Bar Association of Guwahati High Court moved an SLP in the Supreme Court, and the Supreme Court has stated because there is no mandate either in the CRPC or in the Constitution that I'll have to exhaust that and come before the High Court. There is no such mandate even in the CRPC. I'll stand corrected.
And regarding the grounds of arrest,
This is just a...
He is referring to a case by the Guwahati High Court Bar Association itself. Yes.
there is a ruling stating that the grounds of arrest should not be as much as, it should not be like the charge sheet. If it is understandable by the applicant that on what ground he has been arrested,
now if
that
we
is
go
good
by
enough.
if we will call for the your scanned updated CD, that is not a problem. But if you look at page 15,
Yes, Your Lordship.
tell us why he has been arrested. Did he possess it? Was he transferring it? Was he, what was he doing?
He was booked under Section 21B NDPS Act.
So-
And in this present case, he is the driver and he was the
How do we know that from the ground of arrest? That is exactly what I'm asking you. If the ground of arrest doesn't say so, would he understand why he has been arrested? You pick up a man, you give him a piece of copy, doesn't. Okay, heard Mr. M. Biswas, Learned Counsel, appearing for the petitioner. Full stop. This is an application for grant of bail under Section 483 of the BNSS 2023 to the for grant of bail to the petitioner in connection with Saitwal PS case number 87 of 2025 under Section 21B of the NDPS Act 1985. Full stop. Ms. So-and-so, Council, issue notice. Ms. So-and-so accepts notice, is appearing for the state of Mizoram. Full stop.
Mizoram.
The Learned Council, the Learned PP has raised an objection that the petitioner has approached this court without earlier approaching the remand or the remand court at any point of time. Full stop. Same has been answered by the Learned Counsel for the petitioner, stating that it is not a requirement in law that in cases of the present nature, and an earlier approach has to be made to the remand court before approaching the High Court. Full stop. List the matter again on when? Give us a date. When can you have the updated CD?
I am told that it is 15 minutes, the police station is 15 minutes from the High Court.
You are around few hours from here, but we are having a conversation with you. Nowadays, that is not necessary, the distance. It's a scan copy. Yes, when?
Yes,
Next
after 1 week, Your Lordship. Next week.
27th or 28th first?
28th.
28th. List the matter again on 28th of November 2025, allowing the Learned PP to obtain the scan copy of the
My lord, it will be case diary because it is under investigation.
scan copy of the case diary.
Case diary.
Updated case diary.
Let them produce the case diary. Scan copy may not be available, my lord, because in the police station they may not have. In jail, they or the court from there.
Yes,
scan
can you
copy
have a
be called.
scan
But
copy
from
or
police
do you
station,
need
my
to
lord,
have
let
the original
case
copy?
It will be the scan copy, Your Lordship.
Scan copy, they'll provide for it. Why do you worry? Yes.
Absolutely.
Item 9.
I am deeply obliged. I am deeply obliged.
Item 9, yes.
Lord, this is also bail application. My Lord, our main grounds is Article 22(1) as well. The instant applicant is Maramia. Then, my Lord, if I may take a lordship to page 26. Of the application.
26.
Yes, my Lord, that is the seizure and arrest memo. The type copy is on the next page. However, that, my Lord, we are number 2. Maramia. We have put our signature in our own script. And the seizure and arrest memo is also put in English, which I do not have any knowledge of English, as well as my statement is taken in Mizo vernacular. That also I do not know. I don't speak the language.
You say that the arrest memo was prepared in English.
Yes, my Lord.
And a language which you are not conversant with.
Yes, my Lord.
And your statement had been recorded in vernacular.
Yes, Mizo.
Which is not your language.
No.
Okay. And?
My Lord, yes, my Lord. I am from West Tripura, my native. So I do not speak Mizo. Then, my Lord, if I may read the
Where you told your grounds of arrest, where? Arrest memo?
arrest memo was not given to anybody.
You have signed it
I've signed.
at page 27 down below.
I've signed it, but a copy was not even given to me.
The word says received copy. You say that practically it was not given to you. Okay.
But I was not even given a copy, my Lord. My Lord, if I may start reading from the information recorded at page 20.
Yes.
Information report. On 10 p.m. of 13/7/2023, I received information from my source that the associates of Langilnei of Saltang Lili Veng are believed to be transporting a sizable amount of heroin on 2 vehicles, one white Bolero and a red car, brand and numbers unknown. I shall try to intercept the suspected vehicles on the road. Then, my Lord, at page 23 is the report of seizure and arrest. On 13 July 2023, self and my party performed duty at Khadla area and moved to Selling on the morning of 14 July in pursuance of report about 2 vehicles transporting heroin. From Selling, we moved towards Saichal village, Saitwal district. Before reaching the village by about 1 kilometer, we saw our suspected vehicles coming in front of us. The said vehicles were a white Bolero with registration number TR0 so-and-so, and ahead of it was a red Grand Vitara bearing registration so-and-so. Seeing us, both vehicles tried to escape by running in reverse and later turning back towards Saichal. We intercepted the Grand Vitara at the spot, but the driver escaped by jumping off a cliff. The Bolero tried to escape but was halted at Khankon, about 4 kilometers from Saichal from Liapui. However, before it was halted, the passenger of the vehicle also escaped in the jungle of the area. Search of both the vehicle was conducted in the presence of civilian witnesses, and 5.114 kgs of suspected heroin kept in 433 soap cases were recovered from both the vehicles. I seized the said drugs and both the vehicles which carried it. The occupant, namely number 1 Jahir Alam, so and so, from Sepa Hijala district, Tripura, and Maramia, son of so and so from West Tripura, were also arrested. Time of seizure and arrest is 2:15 p.m. of 14/7/2023 at Saitsal. Following this seizure and arrest, I requested SI Larinsanga to arrest the main participant in the case, that is Lalngil Neyi of Taltlang Liliven. On 14/7/2023, by 4:30, the said officer arrested the below noted persons for their suspected involvement in the case, namely number 1 Lalngil Neyi, number 2 Zo Ramchwana, number 3 Vungkanthona, number 4 Amir Hussain, number 5 Sukanta Karmakar. That, my lord.
Nando Karmakar. All that is person. Yes.
That, my lord, if I might take your lordship to page 46, which is the statement of the applicant, the innocent applicant.
Page 40?
46.
6. Huh.
That, my lord, that is Mizo language.
No, but I think page 45 is the actual language you gave the statement in.
Yes.
Page 45 is the
Yes, my
Hindi
lord.
version.
45, 46 and 47.
So 45 is the statement that you gave.
Yes, my lord.
And 46 and 47 is the vernacular version.
Yes, my lord.
So in which language did you give this statement? They would not be giving you the Hindi version.
The English translation is at page 48.
Page 40?
48.
We understand that. But you said that your statement was recorded in
Yes.
the vernacular.
In
But
a language
what is page
which I don't
45
understand.
then? What is page 45?
This is also not my language. It's
It is Hindi. It is Hindi.
Yes, my lord. We are also not
Mera
thorough with
naam
English.
Moram Mia hai. Main 32 saal ka hoon. That is what he is saying.
Yes, my lord.
So this is what he said. They also recorded it in vernacular.
Yes,
and then
my
now
lord.
you have given the translated version. So statement part remains, what can I say? It could be either in Hindi or it could have been in vernacular. We cannot say as of today.
But he is also not he doesn't understand very well as well, no, Hindi.
Hindi?
Yes. He's from,
Okay. And yes, madam, what do you say?
Your Lordship, with regards to the giving the statement in vernacular, etc., the language is not in the petition at all. It is just a upgradation of the
Even then, when
petition.
there are two versions available, we do
Yes.
not know which version he gave.
Yes, but Your Lordship, usually when a person is arrested, then if it is not a language known to the person, then it is recorded in the language known to him, and then translated or recorded in the language known to the officer, and then English. So more or less, it's comprehensively complied with.
Some court had earlier considered a bail application of
yes.
one of the accused.
Yes, it's in page number 152. The Learned Trial Court, Special Judge. The
It is in trial now.
trial is ongoing.
Yes, trial is going on.
And The
Page
reason-
what, page number, what did you say?
152. 156, sorry. 156, and the reasoning given by the learned trial court is in page number 157, starting from paragraph number 4.
Acha, where is that remand order, the first remand order, do we have that?
It will be in the first,
Kindly give it to her. The TCR has been received, no? Kindly give it to her. Can you make that, mark out that page?
Yes.
Strike out that page. Yes. 150.
And the co-accused has already approached this honorable court for bail, and it was rejected by this honorable court.
And that is what I was asking for, that order, if you have that order. Why was it rejected?
Your Lordship was asking for the remand order, right? Your Lordship.
Yes, madam, what do you say about page 157? That ground of arrest need not be in writing prior to Pankaj Bansal case.
Then, my lord, this, as far as our knowledge is concerned, she is also released on bail. I don't know if it was released by the district judge or the High Court. Yes, my lord, this one was rejected.
Which?
This one, the applicant in this.
Page?
Lal Ngilne, the co-accused. It was rejected by Justice Nelson. My lord,
Can you find out, madam, how many of the co-accused, if any of the co-accused have been released on bail? That Justice Silo's order, do we have it?
There are as many as 7 accused here.
however, my lord, 2 were discharged by
Because you
the...
see, what this court is finding, that is why we have asked for the remand order. Whether he was at all told the ground of his arrest even verbally, or did he have the option of filing a bail petition at the time of remand? Recently we have passed one order, have you seen it? Yesterday, I think.
No, Your Lordship.
Yesterday I think it has been uploaded, no, on Friday.
Yesterday was, yes.
I think
yesterday
on
was a
Friday it was
Sunday.
uploaded. There's an order where we have said that yes, we agree with Pankaj Bansal, no difficulty on that. It need not be in writing, but then he has to be told his grounds, and that has to be reflected from the
Evidence.
remand, prior to the remand, whatever document is available in the
Okay.
records. Because even if you don't have to tell it in writing, fact always remains, the law has always been that you must tell him the grounds.
Yes.
If not in writing, verbally you tell him. That is number one. Number two, the magistrate has to make an attempt to find out whether he has been told his grounds and whether he is getting an opportunity to represent himself. Now, if he did not move in bail application at the time of remand, if there was no advocate representing him at the time of the remand, still Article 22(1) would be violated, despite the fact whether he was given it in writing or not. If he was represented, a bail application was moved and rejected, then we can say that yes, he knew the grounds and it was rejected. So that ground would go. But otherwise, if there was no representation, there is no noting by the remand magistrate that yes, I heard him, I asked of him. Because in that case which we have passed that order, the learned magistrate had simply written, there is an application for remand, 1, 2, 3, 4, 5, be that so. And then he proceeds to record the other things. By one stroke of pen, you cannot say be that so. You have to say, yes, I have heard him, or I have told him the grounds, or he does not want an advocate. Some recording of the proceeding has to be there because it is an arrest. Now, in this present case, The petition before me does not give me the remand order, so we do not know what happened that day.
In the remand order,
What does it say?
received so and so, so and so.
Mm.
The said accused is produced in my court under arrest from excise and narcotics custody along with seized articles. Also seen the prayer submitted by case IO for remand and custody of 48 hours till completion of prayer is allowed.
He does not say that I have explained the ground of arrest. Now, if you come to the Caesar memo, if you come to the Caesar
Caesar
memo,
and arrest memo, yes.
page 28,
Yes.
you kindly see this man who has been arrested. This man who has been arrested, the entire story, if you read again, can you read the Caesar memo, madam?
Yes.
I, so and so, yes?
I, so and so, SI of Excise and Narcotics Squad ISO, do hereby seize the below noted articles at 2:15 p.m. of 14/7/2020 from the possession of so and so.
At so and so?
At so and so, the two persons were arrested by me at the same time inside VC house of Saichal village.
Now we just wait here for a moment. They have been arrested inside VC house, right?
Yes.
Things have been recovered from them. Things have been allegedly seized from them.
Yes.
But they were a little down below, you will see that they were trying to drive the vehicle and one of the fellows ran away and this man was arrested. So now whether it was in the vehicle, whether he was driving the vehicle, whether he was the passenger of the vehicle, whether it was strapped onto his body, this Caesar memo does not say the ground why he was arrested.
Yes.
So even without the written grounds of arrest, if we go through these records, we cannot say that he knew the grounds of his arrest. Remand order says magistrate did nothing. In that case, whether there is a violation of Article 22(1) or not. So perhaps that order which was uploaded on Friday, we passed it on when? Yesterday it was uploaded, I forget that name. What's the name? 2-3 days ago.
I will try to find out because I believe that it's my matter.
Should be, that is what I had asked you, that be it so, will that suffice Article 22(1)? If not, then the arrest will have to go. But then we have also to take care that this man is a person from outside the territory. Then what happens? So we have dealt with that part of it also in the order. Where is the order rejecting the bail of the other co-accused? Do you have that?
My lord, it's bail application number 74 of 2023.
74 of
2023.
It was so long ago it has been rejected. (43) of 2025. Now 53 of 2023 and 74 of 2023. Huh?
She has submitted the bail application before this honorable court twice. Bail application 53 of 2023 and bail application number 74 of 2023.
Yes. So, Madam PP, what do you say?
Your Lordship, yes.
Anything you can point out there to show that 22(1) was
No,
complied?
with regards to Article 22, I cannot point out anything from the records.
Then the arrest has to go.
But then I would like to pray that the clear indication in that regard have to be in the order so that I can furnish it further to the concerned authorities for...
These remands these arrests, they came before Pankaj Bansal. So at that point of time, naturally the police did not know that they had to write it all down. But even before Pankaj Bansal, there were several Supreme Court judgments saying that he has to know. And that he was given that knowledge has to be reflected in the records. Supreme Court says that if the police wants to depend upon the arrest memo, or if they want to depend on the CD, then they have to show that yes, this was the time when I told him. They write, we went there, we arrested him, we did this, now I have seized it, now I am forwarding him.
Yes.
One sentence somewhere saying that I have arrested him, telling him that this is why he has been arrested. So he doesn't need to give the copy, but he has to note down that I have told him. Something has to be there.
Your Lordship, with due respect, there are, though I do not have the order now, there are other cases wherein this coordinate bench of this honorable court have rejected the bail application that it has to be, it says henceforth in Pankaj Bansal and all.
That is what I am saying. In Pankaj Bansal
So it
said
cannot be
henceforth,
retrospect.
therefore,
Yes.
that logic that you have to give it to him in writing was not there. But the requirement of Article 22(1) that he must know the grounds of his arrest. At least verbally you have to tell him this is why you are under arrest. Number one. Number two, there are judgments where the court has said that it is the duty of the magistrate to find out whether he knows the grounds, written or verbal. Have you been told why you've been arrested? Yes, sir, I have been told. Enough. Prior to Pankaj Bansal. That is enough. The accused submits that he has been told his grounds. That is enough.
Yes.
But that has to be reflected in the order somewhere.
Your Lordship,
We cannot assume.
Yes, what came to my mind is that the release of arrest will be flooding if this direction is.
If this part is wrong, if there is no indication, then we will rely upon the law which was prior to Pankaj Bansal.
It's always there, Article 22(1).
It has to be there. So now when the magistrate order says, send the prayer for remand, remand. In between, is it not the duty of the magistrate to ask him, or at least tell him that you have a right of defense? That is what Article 21 says, 22 says. He will have the right of being represented by a counsel of his choice. Now the police do not ask him. Who asks him? The first remand court. If there is no indication that he refused a counsel. Because these are not things which are being introduced now. In our practice days, we have seen the
It has always
persons
been
there,
there,
the
yes.
magistrates there always write down. He was offered a counsel, received. Or they write down, accused has said he has engaged his own counsel. Matter ends. He knew the right, he chose his counsel, court is clean. But when you say be that so, or accordingly I remand,
Prayer allowed.
nothing has been done by the magistrate, then will that not create a violation of Article 22(1)? We also have to take into consideration the fact that he has come after so many years saying that so and so that my right was violated. After that he has moved 2-3 petitions. So as of now it is not as if he does not know the ground, but what was wrong initially remains wrong initially. And we also have to take care that that he would be there in the trial court, appearing in the matter if he is allowed bail. And that is for the trial court to see. So what we can do is we'll keep these matters for after some time. That order was reserved on Wednesday. That case was disposed of on Wednesday or Thursday. Do you have the cause lists?
Thursday, I believe. Wednesday was a DB day.
Well, not Wednesday, then Thursday.
Thursday, yes.
Thursday, and I think I have released it on yesterday. Huh?
Don't have it.
Earlier orders are not here. Earlier cause lists are not here. So what to do? You go through that order. We are disposing this of this bill petition. You see if you want anything else? Yes, we'll dispose it off. We'll pass the orders. You'll have it in the afternoon.
Applying, sure, Lordship.
Hearing item 1.
Yes.
We have one issue regarding the hot pursuit. Whether he has authorization to conduct beyond the territorial jurisdiction. So, my lord, in this regard, my lord,
What was the matter about?
Your Lordship, the matter was part heard.
Yes. We were directed to
argue on
regarding the hot pursuit.
Hot pursuit, yes.
Actually, the column...
The jurisdiction part, he had
Yes, my
exceeded
lord.
his jurisdiction, yes.
My lords, in this regard, there is at page 71 of the paper book.
Page
71.
71. What is it?
Look, here the ASILPN, who is the seizing and arresting officer and who is also the complainant, was authorized by his superior officer, who is an empowered officer under section 41, subsection 2 of the NDPS Act, my lords. So in this regard, my lords, I have one notification, if I may produce, my lords, under section 41.
Because otherwise what was being suggested, it will be like a relay race. One man runs from here, crosses the border, gives the relay to someone else, again he runs. Can it be so?
But that notification was issued on 6 October 2015. So that...
Ask someone to get me my tab.
Well, it's the empowered officer. He can exercise only within his territorial jurisdiction, my lord. He can authorize his subordinate officer by issuing an authorization only within his territorial jurisdiction.
This you had given to us on the earlier day, or you had given us some other. I think you gave us this. You gave us one of these to where they can pursue. Yes.
So, well, even if he is the authorized officer under section 41, so he cannot exceed the authorization given by his superior officer, my lord.
Okay. This is what you had argued last time also.
Yes, my lord.
And
This is
therefore
not in
I
my-
was asking you what is the concept of hot pursuit.
This is not in my possession at that time, my lord. So I have obtained it from the commissioner.
This
of
one?
excise. Yes, my
No,
lord.
this is okay. I can authorize someone to do something within the jurisdiction within my jurisdiction. That is something which is done sitting inside AC rooms. Right?
My lord.
But this hot pursuit, chasing someone, KV को बोलिए तो एक मिनट आएगा. KV को. तो chasing someone, catching someone, these are practical aspects. And therefore the concept of hot pursuit.
Well, maybe there may be some issues regarding whether the applicability of the CRPC. So that CRPC section 48 states that, my lords. So without
Because
warrant-
see, the moment we say that one man who is pursuing someone, who's following someone, has to stop at a particular place, then it is not a fair game. This man simply needs to cross the border. It's shown in some Hindi movies, no? मैं आ गया border के इस तरफ नहीं पकड़ सकता. That's in international law. You cross the border, the international police would not have. The police of one district cannot chase you to the other because that will be entering someone else's hostile territory. It may lead to hostilities. That's a different issue. within the same country,
Country.
within the same
State.
maybe not the same state, but within the same country, a central government person, this is Government of Mizoram Excise and Narcotics Department, narcotics is a national issue. Now, he's following that narcotics part, man simply jumps the border and he's safe. Can that be so? It will lead to chaos. Because this is all cross-border business. Rarely it is within the state itself. So if we say that no, you have only jurisdiction to this limited portion, there will be no case of hot pursuit. Yes, KV. Those bail orders, no? Two bail orders have been announced. I need printed copies. The names and the printed copies, two of them I think. So that concept, therefore, I wanted you to argue upon.
Yes, my lords. My lords, in this regard, my lords, may I have some further submission, my lords?
Please.
So that the NDPS Act is a special act. That chapter 5 has included how and in what manner the arrest, search and seizure has to be conducted, my lords. So in that regard, my lords, we may need to look into the section 51 of the NDPS Act, my lords. So regarding the applicability of CRPC.
Just a minute.
So,
Section 51.
Yes, my lords.
Yes.
So, my lords, this is the specific act that CRPC cannot have automatically overriding effect to this special act if the NDPS Act and the notification specifically dealt with how to conduct that search, seizure and arrest and investigation. So it has to be done only within the limits of NDPS Act, my lords.
No, they are not inconsistent with. What if they supplement?
Yes, only on a supplement. If,
so when the
if the Act is silent about something, my lords.
When the CRPF, if the CRPC says that in case a warrant is issued, it can, the concept of hot pursuit would come in.
Yes.
That will be supplementing the NDPS Act, not contradicting it.
Yes, not contradicting.
Then.
But my lords, the Act specifically
it is
dealt
not
with
inconsistent. If it says that you cannot, then it is inconsistent. If you say that yes, concept of hot pursuit would apply, then what happens? Then that part has to be.
He can, the authorized officer can act it only according to the authorization given by his superior officer, my lords. So he can ask the other local police to assist him. So
that is what I am telling you. It cannot be a relay race. It has to be a 100-meter race. If you make it a relay race, that I will run to this point and then you take my relay and you run. But the other man is continuously running. It will be a totally different game. We cannot allow that. If we interpret the law as you are trying to project, then the entire concept would go. Then everybody would be simply jumping the borders and making a claim that I was arrested on that side of the border. I was dragged down. It would be very complex.
But my lords, in my humble opinion, in my humble understanding, my lords, so the authorized officer, empowered officer was clearly notified in the Gazette. And then he can act that only within his territorial jurisdiction. So we cannot breach this notification which was issued under the Act. So the authorized or empowered officer under Section 41 also clearly knows that. He clearly mentioned it in page 71 of the paper book. So that notification number, date so and so, has been clearly mentioned, my lords. He knows his jurisdiction.
And he was authorized to make search at one Mexicab Sumo Colasip to Aizawl service. Okay. Okay. So now for my recapitulation, your arguments, will you give me a short note on your arguments or would you like me to note them down now? I'll need a recapitulation of everything you said. All the arguments that you made, I'd like to note them down. Yes, you have it? Just 1 minute, huh? Just a minute, huh? Yes, Madam PP, you can have a look at this order. Kindly give it to her, that copy. You can also share it with her so that.
Yes.
Go through. Yes, you are reading section?
51.
51. Provisions of the Code of Criminal Procedure shall apply. Okay.
And my lord, 41 also, which is notification was issued at that time.
And what other grounds did you have?
My lord, in the last court, my lord, I forgot to raise that I have prepared.
No, that is why I'm asking you, kindly help me recapitulate what are the grounds
yes,
you
my
took
lords.
up on the last occasion and what new grounds you want to take up now. What was the grounds
My
last
lords,
occasion?
I'll try to make it short. First one is 41, 42, 2 and 43 violation.
41, 42, 43 violation.
And next one, 52A violation. Maybe that does not have a substance.
52A violation, okay.
In my favor.
We'll take it down.
355 violation, custodia.
Then?
And next one is standing order violation, 1 of 89. Next one, sample as well as essay was not produced before the court during trial.
As well as essay not produced.
And material witness, sumo driver was not
During
examined.
Trial. 6. Sumo driver. Not produced.
Not produced and examined.
Not produced, okay.
And contradiction between case IO and seizing officer deposition. Contradiction.
Between?
Seizing officer and case IO deposition.
Contradiction between case IO and CJM deposition and
Investigation was taken lightly. Vehicle registration number was not known, not investigated. Sumo number was not known, not investigated.
Vehicle not identified. Okay.
And next one is, my lord, civilian seizure witness did not know that the accused claimed the parcel box.
Did not know that accused claimed the parcel. Okay.
It was later explained to the witness. That is my.
And you said you forgot to say something on the last occasion?
Yes, that is the not produce essay as well as samples. I have already written, my lord.
Okay, this was your fresh one. Okay. Okay. Yes, madam, did you go through that order that I just sent you?
Yes, I have gone through. I believe that a similar order may be passed.
That is what
Except my only prayer is that since the applicant is the non-resident of Mizoram, so any government servant as
that is what we have given. I think that is what we have given, that it has to be a government servant and one has to be a government servant, one has to be a permanent resident.
Yes,
and it is to be to the subject of the satisfaction of the trial court.
Yes, yes.
And he has to deposit his documents, he cannot leave the territory without permission.
Okay.
Any of these grounds violation,
Fair enough.
move for cancellation. But that violation of Article 22(1) we cannot overlook, despite the fact that grounds were not given to him. In any other form it was given, this court would have supported. Yes.
Yes, my lord.
Did you go to that order?
Yes, my lord.
So your ground that it was not conveyed to him in writing will not apply to cases prior to Pankaj Bansal. This arrest is prior to Pankaj Bansal.
Yes, my lord.
Otherwise, from the records we will try to find out if Article 22(1) had been violated. If it was violated, you are entitled to something.
Yes, my lord.
And if not, if there was, what do you say, compliance of 22(1),
Yes, compliance.
then nothing remains.
Your Lordship, I did not
During
mark
trial
the-
will not interfere, yes?
I did not mark the trial court record, but it's in the first page.
Okay, done.
So, my
Okay.
lord, I have submitted citation memo as well.
Please you give a list.
Yes, I've already given a list.
We'll take it into account. We'll take it into account.
That's what
हो जाएगा. We'll take it into account. Yes, coming back to this case.
Yes, coming back to this case, Your Lordship, I have already made my counter
Others.
on all the others, and with regards to the jurisdiction only. So the fact is that he's a ASI authorized by the superior from Mamit district who have chased. This is the route Aizawl. The route is Aizawl to Mamit via Kolasib. So it's in the midway. Kolasib is in the midway, even though it's a different jurisdiction. So he was waiting for the vehicle, according to the report. And then it is not, yes, it is a fact that he have signed in the seizure and arrest memo. But then my learned friend have rightfully said that he have to take into the aid of the local jurisdiction, police. Now, from the recording of the, from the charge sheet also, the investigation was conducted by the police from the Kolasib. And at the time of seizing and arrest also, Your Lordship, if I may take Your Lordship kind attention to page number 13. This is the deposition of the PW number 2. From the fourth line, we had been waiting for the OC, Kolasib and staff for a few minutes. And on their arrival, they have made the seizure and arrest.
So this man simply ran in and caught him. He did not arrest him.
No.
He detained him for some time.
He detained him sometime, but then the contention of my learned friend have he shouldn't have signed in this seizure and arrest memo, which he signed. Your Lordship, presuming but not admitting that only the local police, that is the Kolasib police having jurisdiction, have the authority to sign the arrest and seizure memo. But then, Your Lordship, this will be on the fact that, on the ground that the OC along with the staff of the police station were there on the spot at the time of seizure and arrest, would only make it a mere irregularity which will not vitiate the trial. Now, it is a settled principle of law that in ND and PS case, mandatory provisions that can vitiate the trial is non-compliance of Section 42, Section 50, etc. And not this one. And not, it does not talk about the jurisdiction. If my learned friend can produce from the statute, from where they can point out that beyond their jurisdiction so and so will vitiate the trial, etc., or the authority, then I would concede. But then there is nothing as such, because this will be only a mere irregularity at the most. Now, section 48 of the CRPC is supplemental to the NDNPS Act. In that, they have the authority beyond their jurisdiction. Now, Your Lordship,
What does 41,
41, yes.
41 of the NDPS, what does it say again? Let us see. Any such officer of gazetted rank of the departments in Central Excise and so on, so on, so including paramilitary forces and armed forces, is empowered in this behalf by General. May authorize any officer subordinate to him but superior to arrest such a person or search a building, conveyance or place, whether by day or by night, or himself arrest such a person or search a building, conveyance, the place. Now, 1986 in the power control section 2 of so governor of some all officers of and above the rank of sub-inspector to exercise powers specified in subsection 2 of this section within the areas of their respective jurisdiction. And you were saying about Code of Criminal Procedure. CRPC, which one?
Section 48. Pursuit of offenders into other jurisdiction. Police officer may, for the purpose of arresting without warrant any person whom is authorized to do arrest, pursue such person into any place in India. Yes, counsel for the petitioner.
Yes, my lords.
This says,
regarding
section 48, are you having that?
Yes.
A police officer may, for the purpose of arresting without warrant any person whom is authorized to arrest, pursue such person into any place in India.
Yes, my lords. It is, as I have already submitted, regarding the applicability of the CRPC. So that section 41, 42 and 43 specifically dealt with it, how to effect seizure arrest. And then regarding section 48.
But those section 41, 42 and 43 that you are saying of,
yes,
that does not deal with cases when a person goes beyond the jurisdiction.
Yes.
So now how do we supplement that part?
Well, that is what I'd like to clarify is that those sections clearly stated that within their respective jurisdiction. But my lords, in this regard, with regard to section 48 of the CRPC, so as per the section, a police officer may, for the purpose of arresting without warrant this officer is acting without warrant, but the authorization given by his superior officer. But that authorization given is only within the respective jurisdiction. So he cannot act beyond the power given to him by his superior officer, my lords. That is what I like to point out, my lords. So because NDNPS Act is a special act, the CRPC cannot have an overriding effect. If the act is silent about something, so it can.
We understand your argument in this way. Suppose a man is authorized by one of the officers here in Aizawl that you can go and arrest. Now he cannot go and do that in another district by traveling from here with nothing on his hands. He goes to some hotel in some other district, waits for some person to come, catches him and then he brings him back. That may not be permitted. But when he is following a particular person, the man is running, that car is driving.
So in the previous...
That is a what do you call a special circumstance, which has not been provided for in the NDPS.
So, well, in the usual practice...
Something has to be done.
Yes. What? He can pursue and chase some person. So, but he has to ask for the local police who has the jurisdiction. So he can detain it.
That was there.
Hold on for some time.
But that is there.
But my lords,
we had been waiting for the OC Kulasib stuff for a few minutes.
But the formal things, arrest, seizure has been signed by him, my lords. So what he has not to do it. So there is the thing. There is some document, my lord.
Where do we find it that the arrest was already done before the police arrived?
FIR is also submitted by him. Arrest memo is at page 64, my lord. 64 to 66. At page 66, at the bottom of
Who
the
signs
page,
it?
he has signed it. Lalpian Puya ASI. And property search and seizure form, which is at page 67 to 69, my lords. At page 69, also at the bottom of the page, at the right side, he has also signed it.
Yes.
That is what I like to point out, my lords.
How does it make a difference? He has committed a crime. An unauthorized person arresting is, say, a peon tries to arrest someone, or a person who is not authorized by anywhere to arrest someone goes and tries to effectuate an arrest. That is being stopped is one part. Okay, we'll take a call on this. We'll try to have this thing. Any case laws, anything on this or on any other subject? Did you give me a list of books? Did you give me a list of books? Judgments you are relying upon, anything?
Submission notes.
List of books, any judgments you are relying
Yes, my lords,
upon?
I have given the other day.
These are the ones, na? You were relying upon. Kindly you verify once. You were relying upon this Noor-Agha. Then you were relying upon Parminder Kaur. Then Chanam Ranjit Maitai.
My lord.
Then Lal Sang Vunga. And SS Muhammad. SS Muhammad Kadri. And you had given me this 3rd of December 2024 document, 22nd of July document, and Narcotics Bureau versus Kashif. Who was depending upon it?
I.
You were relying, no? and you relied upon Rajesh Kumar Raghuvanshi. These two judgments. Anything else you relied upon?
Your Lordship, I have given the list of books, but then I was using only those. I have given the list that I have given is with regards to conscious possession. It's 2025 SCC online SC 122 para 21.
Yes.
And with regards to non-examining of judicial officer, I have relied on 2013 14 SCC 420
Just a minute. 2000?
13 14 SCC 420 para 33. From my list, even though it's in the grounds of appeal, but my learned friend have not pointed out in the oral arguments, SO cannot proceed with the investigation, etc. But then I think it's not required because it's not pressing on that. And Kashif is with regards to standing orders, etc.
Kashif we have here. So, okay.
Deeply obliged.
It's reserved. This is reserved. Judgment reserved. Okay. Judgment reserved. Yes.
Item 2.
Two.
My Lords, Your Lordships, we recall that service matter where we've challenged the major penalty. And my Lords, 2 articles of charge were challenged. One was regarding, my Lords, the discharge certificate given to a patient who had left office of his own volition. And second was regarding the selling of drugs. Unauthorized selling. Your Lordships may have recalled.
Yes.
My Lords had raised, my Lords, our submissions were that the charges in the articles of charge, my Lords, the charge which I had been charged with, or let's say my Lords, the guilt which was proved, the misconduct, that was not part of the charge. So they've travelled beyond the charge sheet. And second is, my Lords, that the IO had relied, so far as the second charge, the IO had relied upon an inquiry, external inquiry report.
Which was not given to you.
Which was not given, and the said propounder of that document was also not examined.
Not examined.
My Lord, that is not a disputed question.
They had a field verification as to whether you were running the show, and then they depended on that also. They referred to it, but that copy was not given to you.
Copy was.
And that was also, was it referred to in the memorandum of charge list of documents?
It was referred. No, my Lord. That is specifically there. The memorandum of charge does not, the list of documents provided does not mention.
Okay, then kindly point out a few page numbers, the memorandum of charge we have.
My Lord's memorandum of charge is at page 39.
Can you tell us the page number of the written statement of defense?
Written statement of defense, my Lords, I've prepared a chart. I'll hand it over, my Lords.
Yes.
I've prepared a small chart, if I may hand it over.
Yes, please do. So you, this preliminary objections and all,
yes,
this was not by the petitioner herself, it was done by some
defense counsel.
Defense assistant.
Yes.
You had taken a very interesting ground saying that the Drugs and Cosmetics Act will not be applicable. That was
My lords, we will not be pushing on that.
Huh? That was something we would like to. Okay, then that is the written statement. Then presenting officer is 157.
Yes, madam.
What is all this in between?
My lords, in between is the
Oh, the annexures.
annexures and the translated versions. They may be there.
I had the occasion to argue a very interesting point. When a punishment is not there
Yes.
in the
Rules.
can it still be imposed? If the circumstances so demand it. Lot of reading went behind it. That was something. And it was a difference between stoppage of increments.
Yes.
So withholding of increments.
Yes, yes.
And the point that was to be argued was withholding of increments, will it be a minor punishment or a major punishment, number one?
Yes.
Number two, when it does not provide for cumulative effect,
Yes.
can it still be imposed?
My lords. My lords, I'll look up on that also.
No, we argued it, we have a judgment in that. But
Though, my lords, I've looked at Rule 11,
Ah.
CCS. The punishment given in this case, my lords, they've given it as per the rule.
it is, these central government, these people, they do it very diligently.
Yes.
It is the departments who adopt that CCA rule, they do not follow the diligence. So they leave a lot of room to argue.
Yes.
Lot of room to argue. Written brief is there, then we have inquiry report 170. We are just flagging it so that it will be easier for us to refer. In the enquiry report, where do they
Discussion, my lords.
they refer to that
Yes, my lords.
other
Page
enquiry, na?
225, it starts. The relevant portion which your lordship is referring to is at page.
It starts at 171.
It's my lords, the inquiry report starts at 171.
Huh?
Forwarding letter is 170.
No, that part where they had a,
Yes.
they held a,
Your lordships, that is at,
inquiry behind your back.
my lords, it starts at 225 and it is specifically mentioned it. Huh?
225.
Yes, the discussion starts from there.
Such a long inquiry report. Wow. 223, 224. Yes. No, this is your reply to something.
Oh, I'm sorry, my lords, your lordships is referring to Article 3. That part is at, my lords, 237. That is the specific, 237. Article 1 is, my lords, different. Discussion is at 220.
The contents of the said inquiry report, na?
Yes, my lords.
This part. Further, as per the inquiry report of Joint
Yes.
Director, now this was never given to you at any point of time?
Yes, my lords.
It is not referred to in the memorandum of charges?
Yes, yes.
And this has been used as a document against you to come to a finding against you. That was the argument.
Correct, my lords.
Okay.
And my lords, this point, my learned friend may have something to say.
Yes, Your Lordship. I had a meeting with the Deputy Secretary, Health Department, Your Lordship. So I apprised him about the whatever has happened in the court in the last hearing, and they have decided that the state is willing to impose a minor penalty contingent on the matter being remanded to the appropriate authority for reconsideration, Your Lordship.
No, but then we cannot remand it if you are considering imposing a lesser penalty. We can remand it back if you are agreeable to reconsider the whole issue
Yes, Your Lordship.
without a reference to the joint director's report.
Understood. Yes, Your Lordship.
If then you have to come to a fresh finding of guilt,
Yes,
whether
Your
he is
Lordship.
guilty or not, and then you can decide what is the punishment to be imposed.
Yes, Your Lordship. That can be done by the.
But just because a report was not referred to,
Yes, Your Lordship.
and then you say that, okay, report not referred to, we'll give you a lesser punishment. That does not take away the illegality in the order.
Yes, Your Lordship. So if a direction may be made for conducting a fresh inquiry, Your Lordship.
Not the whole of the fresh inquiry. You decide the inquiry on the materials actually available before
Yes, Your Lordship.
the inquiry, this thing,
Yes, Your Lordship.
and then you do it. Or
My lords, even though it is very, my lords, appealable, I mean appealing, but my lords, your lordships has seen the articles of charge and the findings.
no, even if we set a penalty order or an order of the disciplinary authority on the ground of non-compliance of principles of natural justice, or
Yes.
on the grounds that you are not given a proper hearing or irrelevant things were taken into consideration, still the Supreme Court says that we can only remand it back.
My lords.
Leaving it at the liberty will be to them to do what they want to do with it.
But my
We
lords,
can set aside the termination
Yes.
order with the liberty to them to do what they want to do in accordance with law.
my
The
lords,
finding has to be theirs.
I agree, my lords.
You are guilty or you are not guilty, the finding has to come from them.
My lords.
This penalty order has to go,
Yes, yes.
and they will come to a fresh decision. That is one way of looking at it. Other way, which perhaps
Yes.
the department is trying to suggest, is this order, it goes, and this order doesn't go. We say that this order is wrong, and we remand it back.
My lords.
They'll see whether the finding of guilt can still be arrived at, and the punishment will still be this.
My lords.
These are the two options. One, we set it aside, give them the liberty. Secondly, we set it aside, remand the matter back
Yes.
to be decided afresh.
My lords, with utmost respect,
Ah.
and my learned friend has been quite fair, my lords. Your lordships, the first may be more just.
Yes, we'll give them the liberty, whatever they want
Yes.
to do, they'll do it in a period of a certain
Understood. Yes, Your Lordship.
time frame.
Yes, Your Lordship.
You have saved us a lot of trouble. Although we'll have to discuss everything he has argued.
Yes, Your Lordship.
My lords, can I just for sake of convenience, if your lordships want to refer to judgments, my lords.
You give us a list. You had referred to Rajit Singh.
Yes, Your Lordship. I had referred it.
Rajit Singh, na?
Yes, Your Lordship. And also, Your Lordship, I had also given a list of cases, but I don't
Legal
know if-
position on
Yes,
scope
Your
of
Lordship.
judicial review in disciplinary proceedings.
Yes, Your Lordship. So that is just a write-up.
What is the latest judgment you have given? Yes, please keep it, please keep it. Hey, you are not coming up anything with in the 2020s, all 94s, 95s. Very recently Supreme Court has said, we are not required to decide.
My lords. My lords, here I just want to take your lordships to the third page of this compilation of judgments. It is rather, yes, yes, please. So my lords, at serial number 11 is with regarding, your lordships had observed with regarding to, my lords, what is misconduct. So what amounts to that, my lords, we've put that specific judgment.
Yes.
And this, my lords, has been recently referred to by this honorable court in a 2022 judgment, 2021 judgment. I have not put that, but I'm just stating, my lords, that this is still relevant. And my lords, with regard to serial number 9 judgment, Rajendra Kumar, my lords, that is with regard to, my lords, what is not permissible is stretching the charge sheet, my lords, the charges, articles of charge.
Here, more than that aspect of the matter, when we remand it back, we will be discussing on that reliance upon a piece of document which was never given to you, and therefore it has to go.
Yes.
And they would be at liberty to do it within a certain time frame,
My lords.
if they so desire, without reference to documents which were not available during the inquiry to you.
Yes. My lords, can I just show, just for the sake of completeness,
Ah.
that particular page where they've listed out the documents. It is
I took it up in the this thing, I think.
My lords,
Page
may-
40 something it will be.
44.
Page 44, they talk about the extract of a message, statement, circular, letter, IMC, and clinical establishment.
My lords, your lordships, serial number 12,
There is a circular,
there is a circular. It is
but
not
that
in-
is not the report.
Yes, my lords. Same for this 13, my lords. This letter is.
It's a letter,
Yes. I just wanted to.
Chief Medical Officer.
Yes.
In fact, the Joint Director was not before the,
Part of it.
and now the difficulty on their part, we should not be pointing out. The Joint Director says that we'll do it again. It was his report originally, which was not supplied to you. Can it stand?
So, my lords, I'll leave it to you, Lord.
Huh? No, we are not going by their concession.
My lords.
We are not going by the concession. We'll go by what the law says.
My lords.
Okay. But this order, you will not have it before Thursday. I don't think you can have it before Thursday. Okay. I'll list this matter again on 20th for delivery of orders.
My
We'll
lords.
deliver the orders on
Yes, my lords.
Tuesday. Yes, any other matter today? No? Finished? Good enough. Yesterday I had the fortune of having my daughters here.
My lords.
Yesterday I had the fortune of having my daughters here.
I see, I
So
see.
the entire day was chaotic for me. I could not go through.
Your lordships must visit
Huh?
the place at, we call it Hangi Lung Lengklang.
I didn't.
They have this see-through walking area.
The Aizol Peak.
Aizol Peak, Aizol.
I went there. We went there. And they have gone back already.
I see.
Leaving me to my duties, and they have gone to join their duties. Anyway, thank you.